Hi, my name is Courtney Brennan, and I'm an associate in the Burns-White Litigation Practice Group, where I focus in the areas of employment, business, and complex and commercial litigation. I hope you enjoyed this segment from a recent webinar, and I hope that you find it helpful. There's been a lot of recent buzz in the world of restrictive covenants, specifically with non-compete agreements from employers who are looking to begin hiring again. And potential employees are coming to them having previously been in a role where they were under a non-compete. Now, these former employees are hoping that courts are going to rule that these non-competes are unenforceable since so many people were let go without cause due to the impact of the pandemic. So now we're trying to foreshadow how these courts are going to rule upon non-competes. There's one example that we're seeing in Alabama of a terminated sales representative who filed an action against his former employer who promised or represented that because of the pandemic, they wouldn't enforce the non-compete obligation against him as he tried to find new employment, but then later rescinded that promise. So there's going to be an interesting dialogue between employers, employees, and as we watch these courts start to make some early decisions on these cases that were filed as early as last summer. But first, there's a practical question of whether the COVID-19 pandemic impacts the legal enforceability of non-competes. And that answer, of course, is going to vary by state. Pennsylvania courts are very fact-specific and decide non-compete agreement cases on a case-by-case basis. Other states, such as Massachusetts, have made everyone aware that they're not going to enforce non-competes for employees terminated without cause, as most of these layoffs were triggered by the pandemic. So employers, just as a practical matter, use non-competes to discourage employees from taking valuable trade secret information and going to competitors. Now, in some respects, given the prevalence of work from home arrangements, employers could argue that concerns about protecting their information are even greater now. We know that at the same time, judges are reluctant to keep people out of work, especially during the current climate. But there's an interesting case out of the Eastern District of Pennsylvania that was filed in June, and we've been following it as it's progressed, regarding a non-compete for a sporting goods retailer in the Philly area who had to close down as it wasn't considered a life-sustaining business. And doing so couldn't guarantee to its employees if they would have employment upon reopening. And so these employees joined another company who competed against their prior employer. And the language in the restrictive covenant agreements at issue contained a clause that these non-compete, non-solicitation provisions were to be applied only after resignations or terminations for just cause. And that did not mention any type of termination without cause or layoff. So obviously, this court found that these non-competes were unenforceable against the former employees. But the court gave further insight to us as it went through the whole analysis and spent great detail talking about, the stay-at-home orders issued by the governor of Pennsylvania, the resulting business closures, as well as highlighting the national unemployment rate and the impact on families across the country. A lot of this type of non-compete agreement case goes into a balancing of the equities, the harm to the prior employer, as well as the individual trying to seek employment. And I think throughout this opinion, the judge took great care to not ignore the bigger impact on individuals who are trying to support families and earn an income. So it will be interesting to see how these cases play out, but there's certainly not a one-sided view at this time.